Welcome back to episode 2, the Shit Your Lawyer Says podcast. We made it to episode 2. I say that like this is episode 50 and we've really accomplished something here. It's episode 2. I've consistently pulled this off 2 weeks in a row, which to be fair is actually very surprising, but I don't even think 2 weeks of consistency is enough to establish a pattern of behavior. So anyways, I'm excited you're here. Thanks for joining us. If you didn't listen to the first episode, you can pick up now. Welcome. I'm happy that you're listening now. Our word of the week is indemnification. Indemnification. So we're going to talk about not just what that word itself means, but also what the provisions look like, what types of contracts you generally see them in, how they operate, what makes them valid, etc., etc. It's one of those areas that I don't care how many times you try to read it on your own. They're going to be dense. They're going to be complicated. So let's sit down and have a little chat about it. If you're interested in learning more about indemnification provisions, stick around. Join us for a bit.
Welcome to the Shit Your Lawyer Says podcast, where we demystify the legal jargon you hear every day and explain it so you can actually understand it. Recording in Dallas, Texas, here's your host, Attorney Jessica Vittorio.
Hey y'all, and welcome back to episode 2 of the Shit Your Lawyer Says podcast. As the intro told you, my name's Jessica Vittorio, and if you didn't join us last week, I am the host of the Shit Your Lawyer Says podcast. I'm a business attorney based in Dallas, Texas. Thanks for being here. I'm excited for episode 2. I'm excited, hopefully, that people are still tuning in. As I said in the preview, our word of the week is indemnification. Indemnification. I feel like this is the type of word, if I was in class, I would like write it on the board, or if this was a television show, it would like pop up. And then as we said every syllable, it would light up in different colors. But I don't have that. Maybe, I don't think I should spell it. Maybe I will spell it. Indemnification. Indemnification. If this was a spelling bee, I probably would have lost the first time I kind of messed it up. But that's okay. It's not a spelling bee. It's my podcast, so we're good to go. Indemnification is the word of the week. And indemnification refers not only the word itself to an individual legal concept, but it can also be a type of provision. Indemnification provisions are something you see in a lot of different contracts. You see them in a lot of different areas, and we're going to talk about both what the concept itself means, just what does that word mean, and also what do the provisions do, how do they operate, and what types of things do you generally see in them. Okay, so before we get started, I have a couple friendly reminders, a couple housekeeping type things. First being, if you haven't already engaged with us on social media, definitely do that. That's how we're interacting. That's how I'm going to get feedback from y'all on things that would be helpful for you to hear. Structure you want changed. Like I said at the beginning, people asked for examples of context, so we're doing that. And also just tell me subjects you want to learn about. I have a whole list, but I'm open to changing it. My mind is open. I'm not dead set on the list I already have. So if there's something you're dying to know about, shoot me a message on social media. You can find us on LinkedIn. You can find us on Twitter, Instagram, and Snapchat at Shit Your Lawyer Says. If you're more of an email person, shoot an email to shityourlawyersays@gmail.com and start the conversation. Engage with us. I love talking to y'all, so feel free to reach out. Second, I want to kindly remind everyone here, and honestly, this wasn't an issue last week, so I'm excited about that, but I do want to remind everyone that this is not meant to be specific legal advice. If you heard the word indemnification and you pulled out a contract that you're getting ready to sign and you are going to base all of your understanding on whether to sign that contract based on my explanation of indemnification provisions right now, do not do that. I'm telling you right now, do not do that. I want to help y'all to better understand what indemnification provisions are, how they impact your life as a business person, make you more educated so you have a better understanding of the things you're signing. But all that being said, these are very specific provisions. And like I said in the beginning, they are dense. They're legally dense materials. So if there's ever a place to spend money on attorney advising, indemnification provisions are one of those places. They have huge, potentially very far-reaching consequences. And so it's not something you want to take some general advice from a podcast on, even a podcast as highly rated and as deeply loved as mine. Get someone to sit down and look at it, have them give you specific advice on what it says and tell you what the implications are, and that's definitely a good place to spend your legal money. So keeping that in mind, the fact that this is educational and not specific legal advice, let's move on to what we're talking about today. Let's move on to what indemnification actually means. So I got some great feedback after episode 1 that it would be helpful if I used the word or phrase in a sentence, gave some context as to where you may find it prior to getting into the nuts and bolts of what it means. So I'm going to work on that this week. I don't know. We'll see how good of a job I do. I feel like I can always count on y'all to be honest with me, which I just love. I really do. I enjoyed the comments after episode 1. I enjoyed the messages that were sent to me. All of the suggestions y'all had were really helpful. So keep them coming. But that being said, in trying to honor that, I'm going to use indemnification, give you some context as to where you may see it so you know where we're going and you can have that in mind for the rest of the episode. So indemnification, like I said, is a concept to itself, but it's also a type of provision. And generally, if you see it in a contract, it's going to be surrounded or part of a sentence that sounds something like, contractor agrees to defend, indemnify, and hold harmless the company along with its partners, owners, members, etc., from all third-party claims arising out of or related to contractor's work, ... so on, continued. And then there'll be an extensive list of parties that are required to be indemnified, situations in which they're required to be indemnified, which we'll get to later on in the episode. But just so you have a little bit of context as to how that word is used. Like I said, contractor agrees to defend, indemnify, and hold harmless the company. So one party to the contract is agreeing to defend, indemnify, and hold harmless. Okay, so now that we have some context into how it's used, the question is, what is indemnification? We can get down to the basic definition. Y'all, can we just say for a second, we're like 5.5 minutes in at this point, and we are already on what the definition of the actual word of the week is. That's freaking awesome. I'm flying through this. We are going so much quicker than next week. We're going to get to the end of 30 minutes and you're going to be like, I have so much new information in my brain and I don't even know what to do with it. It's going to be great. You know how to spell it on a good day for Jessica. We're going to talk about the definition. It's great. Okay. So what is indemnification? The word itself, what does that actual word mean before we get into any of the provisions? So let's start with, like I said, what does the word indemnification just mean on a basic level? If we're at a 30,000 foot view right now, let's start with the dictionary. And I'm not talking about Webster's, I'm talking about Black's Law Dictionary. It's funny because I actually physically own a Black's Law Dictionary. I'm pretty sure it was on my list like 1L year of law school. It is my least used book. I hope none of my professors are listening to this. I don't think I opened it ever one time that I was in law school. I probably should have. That's probably what they're thinking to themselves, but I didn't. I've never opened it until this moment. So we're going to venture in there together and read the Black's Law Dictionary definition of indemnity. And it is a duty to make good any loss, damage, or liability incurred by another. A duty to make good any loss, damage, or liability incurred by another. So if we break that down, if we go back to the contextual example that we talked about in the beginning, where we have one party, at least one party, agreeing to party 2 to indemnify them. So what does that mean? It means, as Black's Law Dictionary just told us, that party 1 is taking on a duty to make good any loss, damage, or liability incurred by party 2. So if party 2 gets sued and they lose $50,000, then Black's Law Dictionary would tell us indemnity means party 1 will make party 2 whole for the loss of that $50,000. Okay, so now that we know what the formal Black's Law Dictionary definition of indemnity, indemnification, indemnify, etc. is, now we ask ourselves the question, how does it actually function? So like we said, what does that look like from a practical perspective in a contract? What does that provision do? And there's a couple of ways when you're talking about indemnification provisions that a couple perspectives you can look at them from. One perspective you generally see indemnification provisions is an insurance perspective. So a contract between the insurer and the insured. That's not really the focus of the podcast here. That's not really what I focus on. So we're not going to take that perspective. Instead, we're going to take a general business perspective. But what I will say is that within that general business perspective, there can be differences between industries. So the construction industry, as we'll talk about a little bit later, tends to have specific ways of dealing with indemnification provisions. And it does vary based on industry specifically, but let's talk generally. So what, in a general business context, does an indemnification provision or clause do? It really just contractually transfers losses and risk between multiple parties. So like we said, party 1 is protecting party 2 from damages related to some specific scenario outlined in the indemnification provision itself. And that can take a couple different forms. There are a couple different types of indemnity provisions that generally address different types of scenarios, and we'll talk about those in a second. But on a base level, like I said, all it means is one party is paying expenses, judgments, costs associated, defense costs, etc. of party 2. It can also, in a business context, apply at an officer, director, board member level. And that's an important perspective as well. Like I said, we're still talking general business, but as those of you in the business world know, there are potential personal liability pitfalls associated with serving in certain positions as it relates to a company. And obviously that also varies by state, but they do exist. So when we say indemnification, not only can it apply to side 1 of a contract, party 1 of a contract, having to pay the expenses of party 2, but it can also apply between directors and officers and the company. So as long as the directors and officers are acting in the scope of their position within the company, they're acting in a fiduciary responsibility to the company, they're acting in a responsible manner, not something outside of the scope of their official duty or something in bad faith against the company, then the company is required to take on that potential loss that they may incur based on decisions or actions they take in their official duty, and they don't have to personally take those on for doing their job, essentially. So those are the two 30,000-foot views of what an indemnification provision or clause does in a general business context. So now, like I said earlier, really these function in different situations. In different situations, party 1 is required to compensate party 2 for the loss in specific situations outlined in the indemnification provision. And that's where we get into the different forms, the different types of indemnification provisions. And so let's talk about that. Okay, so we're about to talk about types of indemnification provisions, but really quickly, I want to address an issue that comes up sometimes when you're talking about indemnification, and that is the requirement to defend and indemnify. We talked about that language a little bit in our contextual example. I said that sentences you'll likely hear, including the word indemnity or indemnify, include contractor agrees to defend, indemnify, and hold harmless, etc. And there's a difference between that duty to defend and the duty to indemnify. Really, as we talked about, the duty to indemnify is just a transfer of the expenses or cost, right? Whatever the damage is, if I have to indemnify you, I have to eat that cost for that damage. Defend is different though. Defend requires me to actively take your place in a suit or to defend you from a suit. And that's important because I may, as a company, have an interest in defending every single suit because I don't want to have a bad case precedent set in the state of Texas or in the state of California that could potentially open up a significant number of cases in other states. So it may be important to me that that suit is actually defended and not settled for a certain amount, or that I don't just agree that I did whatever they're claiming I did and eat that cost. So keep in mind, while a lot of people will say the duty to indemnify, and I have no idea what I just said. The duty to defend. I've been talking for too long. The duty to defend, indemnify, and hold harmless all kind of go hand in hand. But as it relates to defending and indemnifying, that's an important distinction. And that's something you want to be aware of in your contracts, because you have to think to yourself, maybe it's not important to you that the other party be required to actually pay for the cost or actually physically defend the case themselves. Maybe that's not important to you, and that's fine. But there are definitely certain circumstances in certain industries where it's likely that that will be important to you. And really what you want, more than you care about them eating the final cost of any judgment, you really want them to be required to defend whatever may come from their negligence, your negligence, whatever the indemnification provision may say. You want them to have to defend that suit. So that is Okay, so let's quickly talk about some general types of indemnity. I want to preface this by saying that there are a lot of different words or vocabulary used to describe different types of indemnity. Some states use types, some states use names like broad form, reverse form, etc. So it may vary by state. If you're an attorney or if you've heard another name used for a specific type of indemnity by an attorney, don't assume that it's wrong. We're just working off general names here. So everyone may have their own specific way that they go about identifying these different types. But for our purposes, we're going to keep it simple. So the first one I'm going to start with is broad form indemnity. And broad form indemnity is pretty self-explanatory, right? It requires broad, far-reaching indemnification. So party one is required to make whole party two for any of their damages, even if the other party was solely at fault. So what you'll hear, key phrases to be on the lookout for when you're dealing with broad form indemnity are in whole or in part. So even if party two was responsible in whole or in part for the damages caused, party one still has to eat those damages and make party two whole. Another form of indemnity, sometimes referred to as reverse form, is when party one indemnifies party two against losses resulting from party two's own actions, be them actions, negligence, etc. Limited form indemnity, once again, is kind of self-explanatory, but party one is indemnifying party two except for losses resulting from party two's own acts or negligence. These are generally common, especially depending on the industry you're working in. I see a lot of limited form indemnification. Basically just saying, we'll eat your damages as long as your damages, party two, aren't based on something that you negligently did or based on your own act. Another form of indemnity is party-based indemnity. So a lot of times when you say party-based indemnity, it will be for both parties. So both party one and party two indemnify each other based on damages that may occur based on a breach of the agreement. So if the indemnification provision is part of a bigger agreement, a contractor agreement, sale agreement, etc., each party will indemnify the other for damages that may be incurred in the event that the other party breaches. And the last one we're going to talk about is third party. I rarely, honestly, see these types, but they may be common in other industries or in other states. Third party just means party one agrees to indemnify party two for claims coming from specific party three. And they're only required to cover loss or damage based on claims from that specific party. So it's pretty narrow, like I said, limiting it by party that specific way. But as I said, those are the general types of indemnity you're going to run into. Obviously, that is a very high level. We've glossed over a lot, but just so you're aware when you're looking at provisions, how they're structured a lot of times, this hopefully will give you a perspective on that so that you have a point of reference going forward. So important things to keep in mind when we're talking about indemnification provisions and these types we just talked about is that it is very state specific when it comes to what types of indemnification is allowed in varying types of states. Unlike last week when we talked about non-competes, where yes, as we saw, there is some state variation in what's allowed. There is, for the most part, a pretty common form you can follow to at least give you a fighting chance that your non-compete is going to be considered valid, and that's decently consistent across the state's indemnification provisions. You'll see a lot of variety in state validity, so definitely pay attention to that. If you're dealing in indemnity provisions, be aware of what your state-specific laws are, because certain types may be completely outlawed. They may be outlawed only for specific industries. For example, construction generally has some requirements in a lot of states as to broad form indemnity and when you can use it and when you can't. So be aware of industry-specific restrictions, be aware of state restrictions, and definitely look into it on a state level if you're in the process of negotiating your own indemnity provision, or if you're drafting a standard form contract, look into the states where you're going to be doing the majority of your business. Let's talk about real world case studies. Like I said, in every episode, we're going to do a real world kind of current event case study. Where do we see these kinds of things pop up in actual business practice? Our case study today, I would argue, is maybe a little bit of an abnormality. We'll get into that in a second, but I think it provides an interesting case study. So all the articles that I pulled this information from are actually dated today, May 16th. Isn't that crazy? I mean, I could not be any more on point with the current events if I came up with it on my own, if I had just made it up, but I didn't. It's real. It's a real situation. So the case study for today has to do, and to be fair, it's not actually in the court system. This isn't a case that I can point you to. There's been no final decision or final opinion, but we're just going to talk through the situation. So in New York City, both the state and the city are in the process, they're in the final stages of development for expansion of the Hudson River Park in New York City. And environmental groups are concerned partially because this area of the river is going to undergo a lot of real estate development, and that area is disaster prone. So building real estate on it could mean future storm damage to any real estate that may exist on that property going forward. Well, several years ago, in 2013, the governor of New York signed a package of amendments related to the Hudson River project that included an indemnification amendment. And that indemnification amendment, so normally in a public-private or even from a real estate perspective, lessor, lessee context, what you'll see is the individual, the tenant, the individual in control of the property is going to indemnify the actual landowner. So they're going to pay for any damage, either out of pocket, or the way you'll see it, for example, in a personal apartment context, is you may be required to have a certain amount in rental insurance, something along those lines, so that the insurance will pay any damage to the property. But what the governor did and what the legislature did in this indemnification amendment is they flipped that on its head. So instead of whoever is in possession of the property, the investor, the tenant, whoever, having to pay for that damage or being required to maintain a certain level of insurance, the city and state residents may be required to indemnify the current tenant/investor for any loss incurred related to damage at the site. So for example, if a hurricane just devastates that real estate, which the activists argue is likely based on the risk evaluation levels in that zone, then the taxpayers have to indemnify and eat the cost of that loss suffered by the investors and tenants. So that's interesting. The activists argue that could potentially increase liability costs to above $1 billion. Like I've said in the previous episode, this obviously has a political undertone. I'm not making any political statements. Before I get a bunch of angry political comments, I'm not making any political statements here. No one's making a political statement. But I think more than we're dealing with politics here, what this tells us is a couple of things. One, that, we look at the potential increase in liability costs above $1 billion. Indemnification provisions, like I said at the beginning of the episode, can really have long-term lasting impacts from a risk management, risk assessment, liability perspective. So either you're potentially incurring a lot of costs in your risk management outlook for the next however many years, or you're potentially decreasing it a lot if you're the one being indemnified and you're the one who's going to be able to recoup those costs. So I think that's important. I also think another thing this case study shows us is why it's so important to be aware of what these provisions contain and not just gloss over them. A lot of people, to be fair, both attorneys and non-attorneys alike, will say that indemnification provisions as drafted are kind of boilerplate language. A lot of people just stick them places. And this is a great example of why it's so important to really understand what's in them and pay attention to the drafting of them, because you can really turn the intended consequences and the intended power balance of a transaction, a business transaction, on its head if you're not paying attention to these indemnification provisions. So they shouldn't be glossed over. They shouldn't be treated as boilerplate language. You really should be sitting down and, kind of pictorially graphing them out. Hey, I'm party 1 and I'm required to eat the loss for party 2 in X, Y, and Z situations under this indemnification provision. That is important. And I think this case study is a great example of that and why it's important to be aware and very cognizant of the language that's included in those provisions. So there you go. I'll update you if I hear of any updates. We'll keep you informed on social media as this progresses. But if you're looking for a way to think about that in a real life context, or even if you're, talking to someone about indemnification provisions and want to sound smart and sound like you know what's going on in the world, that is a great thing to talk about, because like I said, it's literally going on right this second. So there you go. I hope that case study is helpful to you. And with that, we have made it through episode 2. That was a dense one. I know, y'all, that was intense. We went through a lot of information. If you were still hanging on, I am proud of you, man. We covered a lot of subject matter, and I know that, and I know it's a short amount of time, but I want to make sure y'all are getting your value for the 30 minutes that you're willing to give up to this podcast every week. And some of our topics are going to be a little more in depth. Some of them are going to be a little bit more complex than others, and this just happened to be one of those. But I hope you learned something. I hope you took something away, that even if it's just, the questions to ask your lawyer, you have a little more background information when you're reviewing a contract with your attorney or with your board in the future. Hopefully will help you have more productive conversations related to these topics. Like I said previously, if you haven't engaged with us on social media, please be sure to do that. Twitter, Instagram, Snapchat, Shit Your Lawyer Says. Also feel free to shoot an email over to shityourlawyersays@gmail.com. And with that being said, I hope that you learn something. I hope you take something away from this. I hope I didn't bore you and you're not sleeping right now. I hope that we translated a little bit more shit that your lawyer says to you, and now you can have a more productive conversation going forward. I look forward to talking to y'all next week. Gonna check in with another phrase or word of the week, and I'll talk to y'all again soon. I'll see you next Wednesday.